Pacificus number 2, July 3rd, 1793. The second and principal objection to the proclamation, namely that it is inconsistent with the treaties between the United States and France, will now be examined. It has been already shown that it is not inconsistent with the performance of any of the stipulations in those treaties, which would not make us an associate or party in the war, and particularly that it is compatible with the privileges secured to France by the 17th and 22nd Articles of the Treaty of Commerce, which, except the clause of guarantee, constitute the most material discriminations to be found in our treaties in favor of that country. Official documents have likewise appeared in the public papers, which are understood to be authentic, that serve as a comment upon the sense of the proclamation in this particular, proving that it was not deemed by the executive incompatible with the performance of the stipulations in those articles, and that in practice they are intended to be observed. It has, however, been admitted that the Declaration of Neutrality excludes the idea of an execution of the clause of guarantee. It becomes necessary, therefore, to examine whether the United States would have a valid justification for not complying with it, in case of their being called upon for that purpose by France. Without knowing how far the reasons which have occurred to me may have influenced the President, there appear to me to exist very good and substantial grounds for a refusal. Alliance between the United States and France is a defensive alliance. In the caption of it is denominated a Treaty of Alliance, eventual and defensive. In the body of it, Article the 2nd, it is again called a defensive alliance. The words of that article are as follow: the essential and direct end of the present defensive alliance is to maintain effectual the liberty, sovereignty, and independence, absolute and unlimited, of the United States, as well in matters of government as of commerce. The predominant quality or character, then, of our alliance with France is that it is defensive in its principle. Of course, the meaning, obligation, and force of every stipulation in the treaty must be tested and determined by that principle. It is not necessary, and would be absurd, that it should be repeated in every article. It is sufficient that it be once declared, to be understood in every part of the treaty, unless coupled with express negative words excluding the implication. The great question consequently is, what are the nature and effect of a defensive alliance? When does the casus foedaris, or condition of the contract, take place in such an alliance? Reason, the concurring opinions of writers, and the practice of nations will answer. When either of the allies is attacked, when war is made upon him, not when he makes war upon another. In other words, the stipulated assistance is to be given to the ally when engaged in a defensive, not when engaged in an offensive war. This obligation to assist only in a defensive war constitutes the essential difference between a defensive alliance and one which is both offensive and defensive. In the latter case, there is an obligation to cooperate as well when the war on the part of our ally is offensive as when it is defensive. To affirm, therefore, that the EU states are bound to assist France in a war in which she is at present engaged would be to convert our treaty with her into an alliance offensive and defensive, contrary to the express and reiterated declarations of the instrument itself. This assertion implies that the war in question is an offensive war on the part of France, and so it undoubtedly is with regard to all the powers with whom she was at war at the time of issuing the proclamation. No position is better established than that the power which first declares or actually begins a war, whatever may have been the causes leading to it, is that which makes an offensive war. Nor is there any doubt that France first declared and began the war against Austria, Prussia, Savoy, Holland, England, and Spain. Upon this point there is apt to be some incorrectness of ideas. Those who have not examined subjects of such a nature are led to imagine that the party which commits the first injury or gives the first provocation is on the offensive side in the war, though begun by the other party. But the cause or occasion of the war and the war itself are things entirely distinct. 'Tis the commencement of the war itself that decides the question of being on the offensive or defensive. All writers on the laws of nations agree in this principle, but it is more accurately laid down in the following extract from Burlamaqui. Neither are we to believe, say he, that he who first injures another begins by that in offensive war, and that the other who demands the satisfaction for the injury received is always on the defensive. There are a great many unjust acts which may kindle a war, and which, however, are not the war itself, as the ill treatment of a prince's ambassador, the plundering of his subjects and company. If therefore we take up arms to revenge such an unjust act, we commence an offensive but a just war, and the prince who has done the injury and will not give satisfaction makes a defensive but an unjust war. We must therefore affirm in general that the first who takes up arms, whether justly or unjustly, commences an offensive war, and he who opposes him, whether with or without reason, begins a defensive war. France, then being on the offensive in the war in which she is engaged, and our alliance with her being defensive only, it follows that the casus validarius, or condition of our guarantee, cannot take place, and that the EU-states are free to refuse a performance of that guarantee if demanded. Those who are disposed to justify indiscriminately everything in the conduct of France may reply that though the war in point of form may be offensive on her part, yet in point of principle it is defensive, was in each instance a mere anticipation of attacks meditated against her, and was justified by previous aggressions of the opposite parties. It is believed that it would be a sufficient answer to this observation to say that in determining the legal and positive obligations of the EU-states, the only point of inquiry is whether the war was in fact begun by France or by her enemies. That all beyond this would be too vague, too liable to dispute, too much matter of opinion to be a proper criterion of national conduct. That when a war breaks out between two nations, all other nations, in regard to the positive rights of the parties and their positive duties towards them, are bound to consider it as equally just on both sides. That consequently, in a defensive alliance, when war is made upon one of the allies, the other is bound to fulfill the conditions stipulated on its part, without inquiry whether the war is rightfully begun or not. As, on the other hand, when war is begun by one of the allies, the other is exempted from the obligation of assisting, however just the commencement of it may have been. The foundation of this doctrine is the utility of clear and certain rules for determining the reciprocal duties of nations, that as little as possible may be left to opinion and the subterfuges of a refining or unfaithful casuistry. Some writers, indeed of great authority, affirm that it is a tacit condition of every treaty of alliance that one ally is not bound to assist the other in a war manifestly unjust. But this is questioned on the ground which has been stated by other respectable authorities. And though the manifest injustice of the war has been affirmed by some to be a good cause for not executing the formal obligations of a treaty, I have nowhere found it maintained that the justice of a war is a consideration which can oblige a nation to do what its formal obligations do not require, as in the case of a defensive alliance, to furnish the succors stipulated, though the formal obligation did not exist, by reason of the ally having begun the war, instead of being the party attacked. But if this were not the true doctrine, an impartial examination would prove that with respect to some of the powers, France is not blameless in the circumstances which preceded and led to the war with those powers, that if she received, she also gave cause of offense, and that the justice of the war on her side is, in those cases, not a little problematical. There are prudential reasons which dissuade from going largely into this examination, unless it shall be rendered necessary by the future turn of the discussion. It will be sufficient here to notice cursorily the following facts. France committed an aggression upon Holland in declaring free the navigation of the Scheldt and acting upon that declaration, contrary to treaties in which she had explicitly acknowledged and even guaranteed the exclusive right of Holland to the navigation of that river, and contrary to the doctrines of the best writers and established usages of nations in such cases. She gave a general and just cause of alarm to nations by that decree of the 19th of November 1792, whereby the Convention, in the name of the French nation, declare that they will grant fraternity and assistance to every people who wish to recover their liberty, and charge the executive power to send the necessary orders to the generals to give assistance to such people, and to defend those citizens who may have been or who may be vexed for the cause of liberty, which decree was ordered to be printed in all languages. When a nation has actually come to a resolution to throw off a yoke under which it may have groaned, and to assert its liberties, it is justifiable and meritorious in another nation to afford assistance to the one which had been oppressed and is in the act of liberating itself. But it is not warrantable for any nation beforehand to hold out a general invitation to insurrection and revolution, by promising to assist every people who may wish to recover their liberty, and to defend those citizens of every country who may have been or who may be vexed for the cause of liberty, still less to commit to the generals of its armies the discretionary power of judging when the citizens of a foreign country have been vexed for the cause of liberty by their own government. The latter part of the decree amounted exactly to what France herself has most complained of, an interference by one nation in the internal government of another. Vattel justly observes, as a consequence of the liberty and independence of nations, that it does not belong to any foreign power to take cognizance of the administration of the sovereign of another country, to set himself up as a judge of his conduct, or to oblige him to alter it. Such a conduct as that indicated by this decree has a natural tendency to disturb the tranquility of nations, to excite fermentations and revolt everywhere, and therefore justified neutral powers, who were in a situation to be affected by it, in taking measures to repress the spirit by which it had been dictated. But the principle of this decree received a more particular application to Great Britain by some subsequent circumstances. Among the proofs of this are two answers, which were given by the President of the National Convention at a public sitting on the 28th of November to two different addresses, one presented by a deputation from the Society for Constitutional Information in London, the other by a deputation of English and Irish citizens at Paris. The following are extracts from these answers. The shades of Penn, of Hampden, and of Sydney hover over your heads, and the moment without doubt approaches, in which the French will bring congratulations to the National Convention of Great Britain. Nature and principles draw towards us England, Scotland, and Ireland. Let the cries of friendship resound through the two republics. Principles are waging war against tyranny, which will fall under the blows of philosophy. Royalty in Europe is either destroyed or on the point of perishing, on the ruins of feudality, and the declaration of rights placed by the side of thrones is a devouring fire which will consume them. Worthy Republicans and company. Declarations of this sort cannot but be considered as a direct application of the principle of the decree to Great Britain, as an open patronage of a revolution in that country, a conduct which, proceeding from the head of the body that governed France in the presence and on behalf of that body, was unquestionably an offense and injury to the nation to which it related. The decree on the 15th of November is another cause of offense to all the governments of Europe. By that decree, the French nation declares that it will treat as enemies the people who, refusing or renouncing liberty and equality, are desirous of preserving their prince and privileged castes, or of entering into an accommodation with them in company. This decree was little short of a declaration of war against all nations, having princes and privileged classes. The incorporation of the territories over which the arms of France had temporarily prevailed, with and as a part of herself, is another violation of the rights of nations to which the Convention was betrayed by an intemperate zeal, if not by a culpable ambition. The laws of nations give to a power at war nothing more than a usufructory or possessory right to the territories which it conquers, suspending the absolute dominion and property till a treaty of peace or something equivalent shall cede or relinquish the conquered territory to the conqueror. This principle is one of the greatest importance to the tranquility and security of nations, facilitating an adjustment of the quarrels and the preservation of ancient limits. But France, by incorporating with herself in several instances the territories she had acquired, violated this important principle and multiplied indefinitely the obstacles to peace and accommodation. The doctrine that a nation cannot consent to its own dismemberment, but in a case of extreme necessity, immediately attached itself to all the incorporated territories, while the progressive augmentation of the dominions of the most powerful nation in Europe, on a principle not of temporary acquisition but of permanent union, threatened the independence of all other countries and to give to neighboring neutral powers the justest cause of umbrage and alarm. It is a principle well agreed and founded on the best reasons, that whenever a particular nation adopts maxims of conduct contrary to those generally established among nations calculated to disturb their tranquility and to expose their safety, they may justifiably make a common cause to oppose and control such nation. Whatever partiality may be entertained for the general object of the French Revolution, it is impossible for any well-informed or somber-minded man not to condemn the proceedings which have been stated as repugnant to the general rights of nations, to the true principles of liberty, to the freedom of opinion of mankind, and not to acknowledge as a consequence of this that the justice of the war on the part of France, with regard to some of the powers with which she is engaged, is from those causes questionable enough to free the States from all embarrassment on that score, if it be at all incumbent upon them to go into the inquiry. The policy of a defensive alliance is so essentially distinct from that of an offensive one that it is every way important not to confound their effects. The first kind has in view the prudent object of mutual defense, when either of the allies is involuntarily forced into a war by the attack by some third power. The latter kind subjects the peace of each ally to the will of the other, and obliges each to partake in the wars of policy and interest, as well as in those of safety and defense of the other. To preserve their boundaries distinct, it is necessary that each kind should be governed by plain and obvious rules. This would not be the case if, instead of taking the simple fact of who begun the war as a guide, it was necessary to travel into metaphysical niceties about the justice or injustice of the cause which led to it. Since also the not furnishing a stipulated succor when it is due is itself a cause of war, it is very requisite that there should be some palpable criterion for ascertaining when it is due. This criterion, as before observed, in a defensive alliance is the commencement or not of the war by our ally, as a mere matter of fact. Other topics calculated to illustrate the position that the States are not bound to execute the clause of guarantee are reserved for another paper. Alexander Hamilton.